So good morning, Jessica Mahoney from J&G Law, giving a kind of refresher on the property condition disclosure statement. So this is our third webinar with regard to the property condition disclosure statement. So really, going forward, we're in a different position now. A lot of you, as part of listing paperwork would hand out forms that had to do with the property condition disclosure statement. But a lot of times your statement back would be, you should discuss with your attorney. But, if you give the credit, right, $500 credit, it's an as is deal, which really isn't talking about our current transaction. It's not talking about home inspections or things like that. What it's talking about is what happens after closing, right? What survives the closing. So as the attorney for the buyer, I'm usually adding in a lot of representations into my contracts because I want my buyer to be as protected as possible. The caveat to that being is that most of them don't survive the closing. So our contracts typically end once the deal is completed. And that means that the seller's liability post closing is almost zero. It's really quite rare that there would be a situation to the contrary. Now that we have the New York State property condition disclosure statement as a required document to be completed by a seller, we're seeing now that this survives closing. So the question becomes, what does this mean, A, for my seller? What does this mean as B for my buyer, right? Because now we're looking at this in two different ways. For a seller, it means an opened risk of liability surviving closing. So the statement itself is long. I've completed them with many clients so far, just kind of running through what the questions are. And most sellers seem to be okay with answering those questions. I mean, it's pretty decently fair as to, yes, I have that issue, or I have the knowledge, or I have the whatever you're asking me in this question. No, I don't, or no, that's not present. NA doesn't even apply. Does your basement get water in it? I don't have a basement, so I'm checking off NA. Or I don't know, right? So we can't just go through and just check off I don't know. I get that question a lot. Sellers just say, well, I'm just going to check off I don't know. Okay, well, you can if you don't know. If you do know, then you can't check that one off, right? Because that's where the liability comes in. The liability is not what necessarily the content that you've put in your answer. If your basement gets water in it, for example, and you put that your basement gets water, that does not open you up to liability. What would open you up is making a misstatement, saying that my basement does not get water, or I don't know, and you do know. So that's really where you should be, as a seller, concerned. Am I answering the questions in a way that I'm giving them what I know truthfully? And if the answer to that is yes, then you should not, as a seller, have any real increase of liability post closing that you would have had you given the $500 credit a year ago. So I think that for sellers, and this is what I tell all of my sellers, so long as you are answering the questions truthfully, you're not trying to cover something up, then you're not giving them any information that should be a problem, right? And if it is, it's going to be a problem because the buyer says, oh, the basement gets water, I don't want to buy the house anymore. Well, that's a different story. But you would rather them make that decision now than you say the basement doesn't get water and then it gets water after closing, and now they turn around and sue you because they said that you had knowledge that it had water issues. So that's really, from a general standpoint on the seller side, really the statement is that you have to make everything to the best of your knowledge. You don't have to get the knowledge. That's another huge question. I had a seller call me up recently, and I've had this question actually a few times before the property condition law actually came into effect, the update, basically saying, I'm going to get a pre-inspection done because I want to know, what I have to disclose and what I don't have to disclose. And I'm like, whoa, 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 whoa. You can do that. But my problem with that is that today you don't know the answer to any of these questions, right? These 25 questions, you would probably check off I don't know to because you actually don't know the answer. Tomorrow, after you do the inspection, you do know the answer. And if anybody's ever read an inspection report, which I'm sure most of you have, they're quite lengthy. So for a seller to now have a report with knowledge and have to disclose on the property disclosure every single item that they found out, that's a lot of information. And now it's easily opening you up to the potential that you missed something, right? You missed the comment on page 7. And now you didn't put that in your disclosure. And now you have a report basically saying you have knowledge to the contrary of the answer that you selected. So I really don't think a pre inspection is something that should be done unless there's a specific reason why it might be needed. I think that that's just opening sellers up to have more knowledge that they don't need to have and now have to disclose and really have to be careful about disclosing and making sure that they do an accurate job doing it. I think the more, you know, we're still to kind of switch over into the buyer thing, we're still going to encourage buyers to get home inspections. The property condition disclosure statement is not there to remove that requirement or that suggestion or advice. The property condition disclosure, the way that I look at it and the way that I tell my buyer what it is potentially more information than you would have known. And the reason why is because I have been to home inspections and the home inspector is not permitted to do certain things. Like they cannot move someone's stuff. So if you have a basement that has, a bunch of boxes and the boxes are strategically placed in a way to block where there was an entry of water, there's a potential that you as a buyer having just done a home inspection and your inspector not noticing it because it was covered up, would not have any great protection post closing because of that issue. And you would probably discover it after closing. So what the property condition disclosure is, it gives you now maybe more information. Maybe now because the seller has to tell you what they know, you would now know that there's a water issue, even though your inspection didn't catch it. So it's an informational document for a buyer. It's not to replace a home inspection. A home inspection is still incredibly important. And if anything, when you get your property condition disclosure statement from the seller, as a buyer, it's something that you can maybe look at and say, I have questions about. I need more information from the seller to find out what's going on with this, this, and this. Or maybe I'm going to ask my home inspector if they can dive a little bit deeper into this because of the answer that the seller gave. Maybe they can give me some more information. So really, again, it's an informational tool. From the buyer side of liability, what does it mean after closing if you find something to be untrue? So this came up very recently with a buried fuel tank. So the bane of our existence just on a general day. Now with the property condition disclosure that is asked in the disclosure. And unlike a representation that I would typically add into my contract, as a buyer's attorney, I would say I want a representation by the seller that there are no buried fuel tanks on the property. That representation would not survive closing. So the week after closing, if my buyer found a tank, they would not have any liability there, from the seller because it was discovered post closing and our contract was over. As far as the property condition disclosure is concerned, well, guess what? Now we have the liability surviving. So now what we have to look at is, can the buyer prove that the seller knew that there was a buried fuel tank? This is going to be a tough burden. This goes for everything, right? I'm just using a fuel tank as an example. And I'll use my other example in a minute. But to prove that the seller had knowledge is going to be a tough burden for a buyer. So if I get a phone call from a buyer that says, I can't believe that this happened. I found this buried fuel tank. It's going to cost me $2,000 to remove it. I want to sue the seller. I'm probably going to say, okay, for us to prove that the seller knew that there was a buried fuel tank, it's not going to be easy. To bring a lawsuit, the retainer payment is going to be somewhere around the neighborhood of $5,000 on a normal litigation matter. It could be even more than that. We're going to go to court. We're going to be in court for a while because it's not like an instantaneous thing. And at the end of the day, the court may very well find that the seller had no knowledge that there was buried fuel tank. And that calls into question a few other things, about completing the disclosure. Who is completing the disclosure, right? I have a husband and wife very recently. The husband passed away. He handled everything. So when he passed away, the wife said to me over the phone, I have no clue. I don't even know if there's municipal water. I know nothing. She's like, we bought this house 50 years ago. I'm 80 years old now. My husband did everything. He passed away a couple of years ago. I just want to sell it. I don't know anything. So whose knowledge, obviously, right? We're going based on her knowledge, and she doesn't really know anything. Now the husband may have known a whole lot of stuff, but we don't know it. She doesn't know it. So, she's again completing it to the best of her knowledge. Now we call into question fiduciaries. So, for example, one of the exemptions to completing the property condition disclosure statement is an estate. An estate is exempt because it's run by a fiduciary, someone who wouldn't have the knowledge capable of completing the statement, most likely. Now, think about like my own, parents or my, in-laws. Like, I mean, I have some of the knowledge because I'm their child. So like I've seen their house before, so I definitely could attest to certain things. Not everything. I mean, my in-laws, for example, have owned their house for over 30 years. Like, I don't know a whole lot that's happened really before I came into the picture almost 15 years ago. So then you start thinking about, like, if I'm completing this for someone else, how much can I really attest to the knowledge, right? So that's why estates are exempt. Is a fiduciary who probably doesn't have enough information to be able to answer the question. A trust, on the other hand, is exempt, but only if it's acting as an estate. So, what I mean by that is if I put my house in a trust and subsequently pass away, it's functioning as an estate. So now my trustee, who's making all these representations for me, would be exempt from making the representations because they're doing so in a way that obviously they're like an executor, an executrix, administrator. They're basically in a position where they don't have the knowledge to make the representations. Now, on the other hand, if I put my house in a trust and then 6 months later, I'm like, yep, I'm going to sell my house. Well, I don't, as the trustee, now get exempt from completing the property condition disclosure statement because I'm still here. So I can still make all these representations, and the state is expecting that I do make those. So then we get like kind of the stickiest situation, which just came across my desk. What happens if I have a power of attorney? So mom's in a nursing home, right? So mom moved out. She's in a nursing home. She owns the house in her name. She gave me power of attorney, and I'm the one that now has to complete this statement as a power of attorney. Do I have personal liability as her agent for things that I personally don't know? Right? So if I don't know that there's a buried fuel tank, for example, and there is one, but mom knew there was one, but mom is not necessarily lucid and can't necessarily answer these questions, do I, as the agent, get held liable? Does my mom get held liable? Because she did know, but I didn't know, and I was the one that completed the statement with the power of attorney. There are questions like these that we have to wait to see how they play out to a certain extent. I can give advice to a certain degree, on a case by case basis. But when something is new like this, we're looking for case law. We're looking for the courts to have fact patterns in front of them, like this example that I'm giving you. We're looking for those fact patterns to be answered. So once we can have answers to the fact patterns, then we're definitely in a position where I could give a much clearer advice. So, so we're seeing how that plays out. So again, so now we're thinking, going back to the knowledge situation, we're thinking, okay, so if I have knowledge about an issue, but it turns out to not really be an issue, how do I disclose that on the property condition disclosure statement? And this is where I say, please have your sellers call their attorney before they make the statement. We'd rather them make the statement properly than, let's say, it's not really an issue, not make the statement at all, and have that turn into an issue post-closing. So for example, I had an issue with my septic system a few years ago. I had a septic company come in. They told me I needed an entirely new septic. I have a brand new house. So I said, that's impossible. I can't possibly need a whole new septic system. This is crazy. I just built my house a few years ago. And so, sure enough, I say, you know what? It's probably a good idea. At the advice of a friend of mine, said you should probably get like a septic inspection done. Don't go based on what the septic company's telling you. They want to put a new septic in. So I did that. I called an inspector. He came out. He did a full inspection, and he said it's fine. There's nothing wrong with it. In fact, it's like great. Like your septic's great. So I'm like, okay, wait a minute. He's like, oh no, that guy's trying to sell you a whole new septic system. Okay, so now when I go to sell my house, what do I disclose when it asks me about my septic and whether I've had issues? Did I have an issue or did I not have an issue? And this is kind of like a question I'd get asked in law school. So the answer is that I have to disclose it. There was no issue, but let's just say I didn't address it and I said no. And then a month after closing, the new buyer had an issue with the septic and called the same company that I went to first. And they said, well, we went to the house and we have this whole report where we told her the septic was in dire needs of replacement. Here's the 5-page report we gave to her on why it needed to be replaced. Well, now that looks really bad for me. Even though I had a follow up inspection telling me it was fine, had I just said no issue, I think that there's an argument in court that there was knowledge there that I did have problems. So I would be better off saying, look, I did, this was what happened. Turns out it's fine. Here's the report from the inspector. Okay. So that's really what it's about. It's about giving the knowledge that I had in the situation and that your seller has. So as an agent, what is your role? This is the question I get asked a lot. Your role is that this is a legal document. As much as you may want to help your clients complete this document, it is not something for you to help them complete. So that is something that you can say, I advise you to talk to your attorney. If you have questions about, situations you've had in the past, please speak with your attorney. And if you have, a question as to how, let's say a situation came up, how to address it, that's where we come in. Because the moment you try to step in and help them, you're taking on liability too. And we don't want you to do that, right? We want you to just say, it's a legal document. It's a binding document. It survives closing. So we want you to take a look at it with your attorney, especially if you have questions. And that's really where we step in and we say, okay, tell me about the situation. Oh, you had water in the basement. Okay, how did you get the water? Let's talk about it and let's see. Okay, so that sounds right. So we have to word it in this way. So that way we make it, the knowledge for the buyer. And the buyer may want to do some further digging, right? We're giving them new information. So they may want to know about this. And that's okay. We just have to give them the information. So really that's, just in a general snapshot, just to give an update as to where we stand on the property condition disclosure statement, what it means to sellers and to buyers, and what it should mean for you as agents and what your role is in that. And then as far as I think, really what we kind of thought this webinar would be about, would be, touching base also, like what does it mean in timing of transactions right now. So the transactions, I will tell you that the property condition disclosure statement comes beautifully with an email from the agent. Here's the purchase offer. Here's a transaction summary. Here's the listing, and here's the property condition disclosure statement. I will tell you right now, there's going to be no difference in the timing of that transaction. When we don't get it, that's where the timing issue comes into play. Because we want to get our contracts out. We want to get them out fast to the buyer, right? But the buyer's got to sign the property condition disclosure statement before we have a fully executed contract. So if I don't have a signed property condition disclosure statement from a seller to send to the buyer's attorney along with my contract initially, that means that we're potentially delaying, because even if the buyer were to sign the contract, I can't have the seller sign the contract until I have the partially signed property condition disclosure. So I would suggest that all listing agents try to be on top of making sure that that's out there. Why are we going to not tell buyers about issues until after they've done home inspections? I hear some listing agents are saying, we'll share it with you after the inspection's done. Well, why? That doesn't make any sense. That's a timing issue, right? You still have to give them the same information. So you're not benefiting in any way. You're just doing it after a home inspection, which now could be 10 days after the offer has been accepted. They're now backing out of the deal when they could have backed out the day after the offer was accepted and you could have gone on to backup offers, right? So like now it's a little bit different. Who knows if the backup offers are still around. So I would just be open about it. I think it's got to be part of the documents on MLS, and making it easy and accessible for buyers agents to find it. And then I think from there, making sure that it does get on to the attorney who is drafting the contract, so that way it can be easily sent along with the rest of the documents to be signed. So that's just in a nutshell, kind of where we stand. Should anyone have questions, of course, you can always call or email me. I'm sure that we'll send follow-up correspondence. So I'm happy to answer anybody's question, regardless of whether the file is mine or not. I know sometimes you just need 5 minutes of time, and I'm happy to give that to you. Other than that, I'm going to take questions, but I'm going to stop our recording to do that. So I hope everyone has a great day.